Well, good morning, everybody, and thank you so much for joining us for the December 2019 installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you know, we do these monthly as a quick update on timely issues in environmental law. I'm Ann Navaro, and I'm here today with my partner, Sara Burgin, to discuss our topic of the day, why you all should pay attention to the quality of the administrative process when you're seeking a permit from a state or federal agency, in addition to making sure that you get the result that you want. We're going to cover this agenda item in the next 30 minutes. If you have questions as we go through this, please type them into the comment box on your screen. We'll get to as many questions as we can at the end of the webinar. And if we run out of time, we'll respond to those questions in a follow-up email. So first of all, an overview in terms of what we're going to talk about this morning. I think we can broadly divide it into kind of two topic areas. Why a state or federal agency process, why caring about that process is key to a good result, and why a good process that an applicant is actively engaged in is kind of an insurance policy. And I view it as an insurance policy for several different reasons. One, in order to help the agency get to a good decision, if it's a difficult or controversial decision in particular, a good process helps the agency decision maker get to a good result. It also helps in terms of any public focus on the process, and ultimately, as we'll discuss towards the end, a good agency process is insurance in the event that litigation ensues. So it's important for the applicant to actively and effectively engage with either a federal or state agency in the course of a permit review process. And there are a number of goals of that effective engagement. Certainly fostering an efficient and timely process is key. Establishing positive relationships with regulators and their lawyers to facilitate future permit applications is a major goal. Avoiding last-minute surprises. By being actively and effectively engaged with the agency, you can avoid a situation where the agency imposes terms on your permit or might impose conditions that you didn't anticipate and that ultimately you can't live with. In addition, effectively engaging with the agency helps ensure that your proposal is positioned for agency approval so that the ultimate decision maker fully understands what's being proposed, what issues have been considered, and that his or her staff has fully assessed the proposal. Effective engagement also helps ensure that the permit decision is positioned to survive ultimate litigation to the extent it ends up there. Now, I'm certainly not suggesting that an applicant say yes to everything just to get along with a regulator. There are certainly many points that require active discussion back and forth, but the key is engagement. Now, these concepts that Sara and I are discussing this morning are broadly applicable to all sorts of federal and state environmental reviews, and I'm sure to non-environmental reviews as well. And this slide is just a sampling of all the statutes that are out there that could apply to a project for which you need a permit. These are federal statutes that may be relevant. So first, we're going to talk about the administrative process and how to get to a good result. So for that, I'm going to hand it off to Sara Burgin.
Good morning from Austin, Texas. Thank you, Ann. I'm going to start us out on the topic of careful process and how to avoid surprises with a few best practices that are designed to save time and headache. These are from my experiences with Clean Water Act, Section 402, and of course the state equivalent. But as Ann has noted, some of these practices, or most of them, apply to many programs. The first is to use correct and current application forms. This is pertinent to both federal and state permitting. I know it sounds simple, but it can jump up and sting you if you have an issue. For example, EPA promulgated new NPDES forms within the last year, and these have to be used after June 12th of 2019. This will, of course, become less of an issue as we get farther in time, but it did cause problems for folks this summer and fall. It's important to remember that state program forms can change at any time. And if you don't use a current form, you can end up with situations where you leave something out that can affect your required administrative or technical completeness. I mentioned to use correct forms, and that can occur, the issue can occur when, particularly with NPDES forms, make sure you use the right ones. In particular, for manufacturing facilities, there are different forms for facilities that discharge process wastewater versus forms that only discharge non-process wastewater. We had a situation recently where a facility that discharged only non-process wastewater submitted the form for process wastewater and ended up actually with the draft permit that had additional limitations in it that weren't required. So you have to be very careful in terms of the definition of process wastewater, but if you don't have it, then you can use the form that has less requirements to be submitted. It's important that you follow the instructions. A lot of the forms have instructions essentially attached to the form, but states such as Texas has a very extensive, completely separate document that's on their website with instructions for completing their application, and it's much better to carefully use those instructions. Obviously, ensure that the information in the application is current and correct and complete. You can end up in situations where you're doing a renewal and the consultant or the company folks may kind of just pick up information from the last application that was from 5 years ago and kind of plan to use that, and it's just, you just make sure that you review it and make sure everything's up to date. The next two bullets are sort of concurrent. Make sure that you review the agency prepared fact sheet or statement of basis to ensure that it's correctly reasoned to support the permit requirements. This can be particularly important when you're in a situation where you do need to challenge the permit or the permit is challenged. And as Ann said, work with the agency to ensure the application is well understood and the permit is drafted correctly. Review and comment on an unofficial draft permit if that's allowed and provided to you. State of Texas always provides an unofficial draft, and it's important to use that opportunity. We're actually working with EPA Region 6 on NPDES permits to try to see if they'll begin using unofficial drafts to try to speed up the time for review and issuance of a permit. If necessary, to prevent issuance of a harmful permit containing errors, the applicant must file timely comments and follow the regulations to preserve administrative review. Obviously, the considerations in this, whether or not you have time to challenge a permit and file comments, is going to depend on whether it's a new permit or a renewal where you have an administratively continued permit. So it's going to be a deliberation, but it's one that's obviously important. And back to you.
Thanks so much, Sarah. So now I'm going to talk about some specific recommendations and things to think about as you are helping your client or as you are going through a permit process to anticipate problems that may result before a final decision is made or in the event that litigation is filed challenging your permit. And some people ask me when I talk about these issues, why isn't this the agency's job to anticipate problems that are going to happen and ensure that their process complies with federal law and other requirements that they are subject to? Well, it's true, it certainly is the agency's job, and I'm looking at it from a federal perspective. But while it is the agency's job, as I'm sure you all know, most agencies and their staff are overwhelmed with the amount of work that they have in front of them and often don't have the ability, don't have the attention to develop a record and a permit process as well as it could be. And sometimes that's okay, but sometimes that results in problems down the road. So in terms of an applicant's ability to create a strong record and help the agency reach a positive and defensible decision, there are a variety of things that an applicant can do. Certainly, providing detailed and analytic information on the issues is key, both in order to satisfy the regulator's need for that information, as well as to create a strong record that allows the decision maker to make an informed decision and create a defensible decision. It's important, as we will see later when I discuss a couple of cases, to be really good about documenting all concerns and comments and helping an agency to evaluate those and respond to those. And it can be very resource intensive, because in some federal permit processes where there is public comment, an agency could get hundreds and thousands of comments on a proposal. And there may be an opportunity for the applicant to help the agency respond to those. And that can be critical down the road. It's also important for an applicant to be consistent in how things are described, both publicly and with the regulator, because if things conflict with each other, that could create later problems. Of course, it's also very important to be consistent in how a project is described and in how your project is described in the context of agency jurisdiction. There can be problems if an agency appears to be taking jurisdiction that is outside of its statutory authority, whether a state or federal agency. That can create later problems in litigation. If a plaintiff suggests that the agency has not fully analyzed the project, even though the agency in reality only had jurisdiction over a very small piece of it. It's also important to recognize that satisfying an agency in its request for information is not necessarily the same as satisfying the legal standard that's applicable to their review. It's certainly satisfying when a regulator says, well, we've got enough information, but sometimes an agency may be fine with less rigor than is later demanded by the ultimate decision maker or, in a worst case scenario, by a judge. And then the last point I'll make is, I'm sure many of you on the phone are aware that in this administration, federal agencies are making a concerted effort to undertake regulatory processes together. That's known as the one federal decision process. So where there are significant projects of certain types that require multiple federal agency reviews, agencies are supposed to be working together in order to create one environmental review to support each of their decisions. And this is a great idea that is still in the process of evolving, but it also creates problems where agencies have not yet really figured out how to work together. And so that's also where an applicant can help in order to ease that relationship and help create combined documents that really look through all the issues. Sarah, did you have something to add there?
Yes, on the topic of, to sort of second Ann's point that satisfying the agency is not the same as satisfying the legal standard, I just had one specific comment that I wanted to mention. Although I'm not aware of a particular permit challenge based on the issue, I worry that the TCEQ Water Quality Division has sometimes been too lenient regarding the issue of submittal of quantitative data with an application on the pollutants that are expected to be discharged in the context of a new permit or a permit that has had very intermittent discharges. You know, most applicants for a new permit provide the estimates that are directed by the regulation on the quantities and quantitative information on the pollutants to be discharged. And that's required by the regulations. But I have heard that in certain instances, consultants have approached the agency and the agency has agreed to allow an applicant to essentially leave those quantitative information forms blank and instead just submit data after the permit has been issued. The TCEQ will include a table of data to be submitted once discharge commences. And my concern is that such a permit would not withstand a challenge essentially related to, number one, whether the application was completely filed and whether there's a permit shield for those discharges. Because without that estimate of the analytical data, the agency, the permitting agency, in this case the TCEQ, doesn't have all the data it needs to conduct the reasonable potential review of whether or not water quality-based limits need to be included in that permit that they're issuing. The idea is that once they have the data, that they may initiate an amendment to the permit to add those limits, but oftentimes that does not happen during the entire term of the permit, and I think there's issues there. So I wanted to mention that just so folks make sure that they do provide the estimated data. Ann, back to you.
Thanks, Sarah. All right, litigation. This is where the rubber meets the road. Hopefully for most of you, you will make it successfully through a federal permit process, and your permit will not be tied up in litigation. But as you all, I'm sure, are aware, litigation against federal permit decisions, challenging federal permit decisions, is not uncommon. And private projects may be significantly affected by litigation against federal agencies. So how does that happen? Federal permit decisions, as well as other federal actions, can be challenged for violations of a whole range of substantive or process statutes, from environmental laws like the Endangered Species Act, National Environmental Policy Act, Clean Water Act, and they all get challenged pursuant to the Administrative Procedure Act. Under the APA, a court can set aside a federal permit decision found to be arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. And in reaching its conclusion, a court is going to generally rely on the agency's administrative record of that decision. So that's the record that you as the applicant helped the agency put together in order to support its decision. And that's why it's so critical. A permittee, so a private party, is not always named in this kind of lawsuit. Sometimes is named, but the permittee often intervenes in order to protect its interests in the federal permit decision. And at the end of the day, a court can, and often does, enjoin temporarily or permanently the efficacy of a permit. And I see there's a typo on this slide. Of course, that injunction would render that permit unusable. And so it could stop or delay or significantly complicate a private project, which is why helping the agency and being actively engaged in its administrative process is so critical. So why are permits challenged? It's generally not because a federal agency has done something that's patently and absurdly illegal, because agencies follow the process and they generally implement their regulatory programs consistently and with a great deal of responsibility. It's often because the project at issue is controversial, because of impacts to protected species or cultural or historic resources. They may be challenged because stakeholders in the area of the project have different views of use of the resources. They may be challenged because local governments or states or others have different policy perspectives on the particular federal program where the action is subject to jurisdiction. And courts do overturn federal permits. And they do it for reasons that are very fact-intensive, often very dependent on the agency's administrative record, because they are often looking at whether the agency has really considered appropriately the impacts of the potential project before it, and whether the agency has really provided a sufficient explanation or clear explanation of its conclusions. So often permits are not overturned because there's a violation of some underlying environmental requirement, but it's often a failure of process. And it's that process that the applicant, again, going back to active engagement, can really make a difference in as a permit application is being processed. So I wanted to talk about just a few examples of how this plays out in federal litigation. And the first case on this slide, Friends of the Earth versus U.S. Army Corps of Engineers, is an old decision from 2000, but I chose it because I was the defense attorney when I was at the Department of Justice in this case, which was many years ago. And it is a case I lost for process reasons. It was a challenge to permits issued by the Corps of Engineers under the Clean Water Act, where the Corps had an obligation to consider the potential environmental impacts of the permit under the National Environmental Policy Act. And federal permits are frequently challenged under NEPA. In this case, the court simply found that the Corps' environmental review was lacking, not enough detail, very conclusory, and the court concluded that additional environmental review was required. So in this case, the projects had not begun construction. The permits had been issued for activities related to the construction of some casino barges in Mississippi. And the court actually vacated the permits. So the private applicants no longer had permits that allowed their construction. The projects, at least in that formulation, were no longer viable, couldn't tolerate the time or money required to complete an additional environmental review. So the projects as formulated did not occur. So that's an example of a situation where the defense attorneys who are dealing with litigation, either the government attorneys or private attorneys, can only defend what the agency has created in the administrative process. So by the time it's in litigation, as good as the attorneys handling the case may be, they are stuck with the agency's administrative process, which is why it is key to be actively engaged in that process. Then the second decision is a more recent one, which you all may be very familiar with. This is the Sierra Club versus FERC case, where the Sierra Club challenged the FERC Certificate of Public Convenience for a pipeline, a gas pipeline, the Sable Trail pipeline. And the court found that FERC had failed to consider, under the National Environmental Policy Act, greenhouse gas emissions in its environmental review. So it actually vacated the certificate, and an operational pipeline was temporarily shut down while FERC fixed the problem and went back to the court to lift the injunction. So those are real implications for private projects from failure of federal permit process. A couple additional examples where the projects have not been enjoined or stopped and in fact are constructed, but where environmental review is still ongoing, so to some extent there's an uncertain outcome. In the most recent decision, the one on the left-hand side of your slide, in the National Parks Conservation Association case versus Semonite, here groups challenged a Corps of Engineers permit related to a transmission line across the James River in Virginia. The district court had upheld the Corps of Engineers permit, and in fact the transmission line was constructed. But on appeal, the DC Circuit disagreed and concluded that the Corps' environmental review was inadequate because the Corps didn't sufficiently consider historic effects. And in this case, the court particularly noted that there were voluminous comments from expert agencies, in this case the National Park Service, related to the potential effects of the transmission line that in the DC Circuit's view, the permitting agency had failed to sufficiently address. So again, that goes back to it being critical in a permit process to sufficiently address comments that come in on a particular proposal. Here, the DC Circuit actually remanded the decision to the district court to consider remedy, whether the permit should be vacated and even perhaps whether the existing transmission line should be removed. The district court just recently concluded that the permit didn't need to be vacated and that the line didn't need to be removed, but the Corps is continuing in the environmental review ordered by the DC Circuit, so the case is not over and the ultimate fate of the permit and transmission line is currently unknown. Similarly, I'm sure most people on the phone are aware of the extended litigation that has occurred over the Dakota Access Pipeline project. Again, this has been a challenge to Corps of Engineers decisions related to construction of that pipeline. And while the pipeline has been constructed and is fully operational, this is another example of where the court found some failures in the environmental review, and those are still being remedied. So again, the ultimate outcome there is to some extent unknown. So that's an overview of why the administrative process is so critical, even if you get a positive permit decision, if the worst happens and you actually end up in litigation. Sarah, do you have anything further to add?
No, I think this is a great job.
All right. Well, thank you so much, everybody, for attending today, and we will talk to you next time in January.